Good morning in America. Good afternoon in the UK. I'm David Wencup from Squires. We are here to talk about the UK government's proposals for employment law reform as they affect restrictive covenants. Now, I'm going to make a confession right up front. You may detect an element of irritation on my part as we go through this webinar. That is not because I managed to spill an entire cup of coffee down myself, which is why I'm sitting so low, but because to get it out there up front, this proposal has no legal or business related merit whatsoever. And it is, as you'll see, if you'll forgive a rather unconventional start, this is naked politics. It has nothing to do with the benefit of the people it's aimed at. The consultation document is full of non sequiturs and blanket assumptions and quite a lot of politics, and it's really just not the right thing to do. Normally, you can see both sides of an employment law proposal and you can say, well, don't happen to agree with it, but I can see the thinking behind it. This one, you just can't. And I point you to this, which is a 69-page document issued by the Department for Business and Trade, which, if you read it, will leave you absolutely none the wiser as to why this is happening. It really is an extraordinarily inept proposal. So everything I am going to say should be seen against that view. I feel much better for saying that. Thank you. So let's get on with the webinar. I'm joined today by Carmen Cole, partner in our Los Angeles office. It is, of course, bright and sunny in the valley this morning, the way it is in every Los Angeles day. She is going to talk towards the end of the webinar for about 10 minutes on the position in the US and specifically or mostly California, because they don't have non-competition clauses there at all. And so we thought it would be helpful to look at what measures employers are taking there to work around that. So you'll get to Carmen a bit later on. First of all, you get me. And you will see, oh, that's interesting. Multiple, I'm pressing the wrong one. I'm so sorry. There we go, that's us. First of all, we get to the UK position. The UK position is that we have had non-competition clauses around for a very long time, hundreds of years, and that they have been enforceable for all those hundreds of years, provided that they are no wider than reasonably necessary to protect a legitimate business interest. Now, that sounds a bit like a legal lecture, but the thing is that over hundreds of years, thousands of judges have listened to tens of thousands of cases about what is reasonably required to protect the legitimate business interests of businesses, and they have decided that that includes non-competition covenants of varying degrees of length and breadth. But the common law in the UK is absolutely nailed on to the principle that these things work. And there have been some recent cases, the names don't really matter, some recent cases which make it quite clear that these can last for 12 months even, probably not more and often less, but up to 12 months. Some really very big legal brains have decided is a legitimate protection for an employer. Now we're looking there at the three different sorts of legitimate business interests, mostly customers, staff, trade secrets and confidential information, yes, but it's essentially to protect all of those which a non-competition clause is aimed at. Now the key there is that the competition would have to be unfair. These clauses don't permit employers just to stamp out competition generally. It's got to be competition which would be unfair because the ex-employee is benefiting from their basically from the employer's investment in them, in the connections they've built up internally or externally, in the knowledge which has been conveyed to them. And it's an accepted principle that they should not be able to just run away and exploit all of that. That's what non-competition clauses are about. The reality behind this is that these clauses are extremely difficult to enforce. They are fantastically expensive to enforce. You're looking at close on £100,000 without very much difficulty at all. And if by any chance yours is a tiny bit too wide and therefore completely valueless, then you're looking at paying the other side's £100,000 as well. So these are not commonly exercised clauses. This is serious sledgehammer to crack nut stuff, but it's not, as I say, for anything other than really electioneering. So we'll move on, I think. So this is what they do. We're not talking here about non-solicitation of staff or non-solicitation of clients or non-interference with suppliers. All of those things carry on exactly as they were. The only one we're talking about is pure non-competition. You cannot go and work for a competitor. Of course, the devil's in the detail, and that has to be reasonably defined as a competitor in terms of the activities, the duration, the geography, and so on, as you can see there. But if you can get all of those things right, and you can show that there is a meaningful risk that if the employee goes to a competitor, they either will or basically will have to, by the nature of their job, exploit those connections, that information, then these things will stick. So that's where we are at the moment. Now, what's planned? Before even we get to this slide, there was another call for evidence in 2016 about changes to the restrictive covenant regime, and that was posited entirely on the basis that restrictive covenants were damaging to startups, and startups are going to be the new lifeblood of the country after Brexit and a whole load of political waffle and red, white and blue and Elgar and so on. Startups are the way to go. And so the government said, we want to consult around possible variations to restrictive covenants because they are damaging startups. The answers to the 2016 consultation just vanished. The whole consultation just disappeared. It's like a Thameslink train. First it says it's late, and then it says it's delayed, and then it's as if it never happened at all. It's a very, very weird thing, but it just disappeared. But then suddenly out of the blue came along this one in December 2020. They're having another go at it. This now has no reference to startups at all in it. I think on the basis that they discovered that the previous one just had no logical sense to it at all. So instead they make these two proposals. We will make employers pay for the duration of non-competition clauses, or we'll just get rid of them. Now, when it says pay, they meant pay because the consultation offered a range of possible pay rates which employers might have to pay, which ranged from 60 to 100% of normal salary. So this wasn't a notional figure. This is a pretty chunky price which they were thinking of attaching to non-competition clauses. So there were some answers to that. Not many, as we'll come back to, but there were some answers to that. And that disappeared as well. I think basically on the basis that both ideas were really quite stupid. But either way, they've disappeared. And then what we get is this. The government's proposals for change, smarter regulation to grow the economy. This is, I would say, a really depressing document. It is depressing because this is one of the proposals attached to it. There's another four. They are a truly woeful little bunch, as the best sparks to the Brexit bonfire that we could get. Have a look, but it brings tears to the eyes. It really does. But the one we're concerned with here is to limit the length of non-competition clauses to 3 months. That's it. That's what this is about. Note when parliamentary time allows, which is of course shorthand for sometime next time, possibly never, but it's there, and it's going to apply to employees and workers, but there's not going to be a ban, and you're not going to have to pay for them. But it is limited to 3 months. That's the issue. All right, well, fine, but why? Why would you do that when hundreds of years of enormously intellectual rigor has been applied to this same question and come up with the answer that a much longer period sometimes works? Why would you do it? And you get this. This will give 5 million, really, workers greater freedom to switch jobs and get a pay rise, which the government puts in its consultations about pretty much everything these days because it's a little political. Boost, you might get a pay rise. Well, why would you switch job if you weren't, for one thing? But the only basis on which you get greater freedom to switch jobs is that you can take with you, seemingly, the information, the connections, basically the investment of your former employer. And this extract, which comes out of the document I showed you earlier, this says supporting employers to grow their businesses, but it just doesn't. There's just no connection at all between what we're talking about and growing businesses, unless you say, well, we can grow businesses by exploiting what was, until this came into force, the proper business interests of other employers. And particularly if you have regard to the idea that this started with startups. So you're a startup, you're staggering along, you've got this brilliant inventor's garden shed idea that could transform your business. And then somebody says, well, I'm sorry, boss, but it's a bit hand to mouth here, and I'd sooner go to a big employer with a regular wage. I'm off. I start on Monday. And with that, prospectively, goes your IP, your ideas, your information, possibly some other stuff. How does that support employers to grow businesses, particularly little employers that this was originally ended at? So there's a gigantic non sequitur in the middle of this as to what actually the benefits will be. Now, this says up to 5 million workers. There is nothing in the consultation document as to where that number comes from. There is a suggestion that the average non-competition period is 6 months. That strikes me as very much on the high side. But remember that a non-competition clause which is too long is void. It isn't that there is a way of keeping people out unnecessarily, because there isn't. The courts will just strike them down. So it's the reasoning behind this is a bit iffy. Reducing barriers to recruitment, well, it won't reduce barriers to recruitment. It might allow you to get certain people more quickly, but you can get the same people at the same cost as you could before, just delayed a bit. The guidance at the bottom, frankly, I can't wait. I cannot imagine what that is going to say. But one of the earlier 2016 proposals was that there should be additional measures put in place to make sure that employees were aware of the significance of restrictive covenants they were signing up to. And there was a view that might mean something akin to the sort of external advice you have to get to sign a settlement agreement. So you've had the opportunity to take legal advice as to what this covenant means. I mean, call me old-fashioned if you will, but I would have thought that the sort of person who had a meaningful non-competition covenant would be able to read it themselves. And so, yeah, anyway, look out for that guidance. It'll be a peach one way or another. So we'll see. So potential benefits, political fluff, potential downsides, serious exposure to businesses who have IP client bases and so on, which are not easily protectable through the use of confidentiality wording, garden leave, that sort of thing. So it does seem a bit back to front. Now, here is a picture of a company officer about to throw himself off a cliff. These are the downsides. So if here we are, we're post-Brexit, we're trying to be the new startup intellectual capital hub of the world. And what we are doing straight away is creating an environment where your inward investment can be put at risk much more easily than was the case before. So somebody hasn't really thought about that, I think, but never mind. Hampers parties' freedom to contract. Well, you might say that that's true, but remember that there was already as you see at the third bullet, a very significant body of case law. Yes, it confirms that non-competition clauses may be necessary and that they may last a fair while, but it also confirms that if they are an inch wider than needed for that purpose, they're void. There are no points for a near miss when you're judging the validity of restrictive covenants, particularly not non-competition clauses. So if you've defined competition too widely, if you've got the activities too wide, the geographical area too wide, the period too long, you get nothing. There's no adjustment by the court. You may have seen in your contract or somebody else's a clause which says, however, if all of this is thought to be too wide, then you agree that the court may amend, modify, or delete such as it requires to make it reasonable after all. These don't work. There's no finer way of putting it. It's called a blue pencil clause after the pencil used by the wartime censors, and all the censors could do was delete, not amend. So all that principle allows judges to do is delete, not amend. But you can't delete bits of a non-competition clause and leave anything sensible behind, because it's either you fundamentally change the meaning of it, which you're not supposed to do, or you end up with you will not for deleted months after you leave, which makes it completely valueless. So there is a lot of case law, all of which is ignored, except that the government says that within the 3-month period which it does allow, the common law principles will still apply, meaning that 3 months is not a sort of minimum, it's not a target, it's a maximum. And that if you have a non-competition clause for 3 months, when a court decides that 2 would have done, you lose. The trouble, obviously, is that for 3 months, nobody's going to bother, because that's the length of most notice periods at the professional level anyway. And if you're not professional, you shouldn't be having a non-compete there in the first place. So it's notionally, it pays lip service to the continuation of non-competition clauses, but in practical terms, this pretty much kills them, because everybody's going to rely on garden leave instead, because it's much, much easier to enforce. What it isn't is that effective instead. So, mixed reviews for that one. It says their confidentiality and non-solicitation clauses may not be sufficient. We know that because that's the whole basis on which non-competition clauses were allowed to arise in the first place. If you had a risk which could be dealt with by confidentiality and non-solicitation, then you wouldn't get a non-competition clause to stick. So we know they may not be sufficient, and yet despite that, this measure is still proposed. So look at the last question. What are we going to do with the contracts we've already got? We don't know, but the likelihood that the law will retrospectively affect existing contracts is extremely small. There is a principle of lawmaking which says that that shouldn't happen. But that means that if you have a covenant now, then you should be looking at that and saying, well, is our 12-month non-compete too wide, or our 9-month or our 6-month? Maybe we could cut it down a bit in preparation for the new law. Well, I'll tell you what, we'll do it when the new law comes in. It's my view that subsequent variations, even to existing contracts, will still be caught by the 3-month cap. So in other words, unless your covenant is right before we get there, at longer than 3 months, then your ability to amend it afterwards is basically shot. So the lesson from this is have a look at those restrictions now. If you decide secretly that you've maybe overreached yourself in giving somebody a long non-competition clause because it seemed a good idea at the time somehow, but their career or their job has evolved such that it isn't really appropriate, then fix it now, because it's going to get hard later on. All right, so Carmen, what do we do? I'm going to come back and talk about the UK position here in a moment, but what's happened in the States as part of all of this? Before we get there, just one thing, if I may, I'm sorry. I did say there wasn't very much evidence submitted in response to the call for evidence. Now, Carmen has told me that the US equivalent received 20,000, was it? More than 20,000?
Yes, 20,000.
Right. How many responses to the call for evidence did they get in the UK? Well, I won't ask for answers, but it was 104, of which less than a quarter were employers, scarcely a third were employees, and all the rest were lawyers trying to make a name for themselves and trade unions. So this whole bit of law appears to be based on the entirely self-interested feedback of about 60 people. Now, on that unpromising start, Carmen, over to you. Tell us about an altogether more considered US position.
Well, thank you, David, and I appreciate you sort of setting up the context conceptually of what's happening in the US. Now, the US has, it's a little bit, I don't know if it's more complicated, but it is a little bit different in that in the US, our states, the current position was that the states, the individual states within our 50 United States could determine whether in fact they wanted to enforce non-competes. So that's just something that states get to decide for themselves. Out of our 50 United States, there are only a handful that prohibit non-competes altogether. North Dakota, a large state geographically, but the population is very small. Massachusetts is another state that does not enforce non-competes, does not find them to be lawful or enforceable in any way, shape, or form. Minnesota, just recently, within the last month, has determined that as of January 1st, they will not have non-competes. And of course, the big one, California, where I live and have practiced for the last 22 years, non-competes have always been unenforceable and considered an unlawful or unfair business practice that unlawfully restricts trade. Now, in the states that I mentioned earlier that are less populous or more small, it seems like it's not that big of a deal. But the question is, how can a state like California exist, as the 5th largest economy in the world without non-competes? Some of that actually goes to David's point earlier, which is that California, if we're being honest, is the probably the capital of the world in terms of startups. Tech is here. Google, Apple, all of it. Tech is really, California is the land of tech and startups. Yet, in this state, we've been able to successfully grow to, as I mentioned, the 5th largest economy in the world without the imposition of non-competes on California employees. Having said that, our U.S. Federal Trade Commission has actually proposed a new rule that is not entirely unlike the rule in the UK that David has spoken so eloquently about and educated us all on. The difference is that instead of prohibiting non-competes or limiting them to only 3 months, the U.S. Federal Trade Commission, which governs, it's federal law that governs all of the United States, is proposing to eliminate non-competes altogether, regardless of duration, geography, or time. So I understand the proposed UK rule limits them to 3 months. The US rule is even broader. It disposes of them altogether. And that law, if it goes into effect, will supersede all contrary state laws. So the other 46 states that impose non-competes currently, that all goes away. That law is eviscerated, and that right to impose non-competes will be taken from the states. It also includes sort of individual rescission of the non-compete provisions, not the entire agreement. So under the FTC's proposed rule, it's just the non-compete portion that would become unenforceable. So the remainder of, say, an employment agreement or an option agreement or a restricted stock unit agreement would remain in effect, which means that if there is some sort of employment arrangement where an employee receives some sort of monetary or financial incentive to join a company or to sign an agreement, they get to keep the money, even though the non-compete language that is really there to enforce it goes away. And this is applicable across the board to all types of employees, interns, contractors, volunteers, you name it. So that's the proposed rule in the states, to which, as David mentioned, there have been more than 20,000 comments in opposition to this rule. So it's hotly debated. What I've told my clients across the United States, based on my experience in California, is that as scary as this rule sounds and as awful as it sounds, the sky hasn't completely fallen. There are some ways to challenge the proposed rule. And even if the rule were to take effect, there are even some creative ways to live without competes, as we have in California all of these many years. I will say that there are some very limited exceptions in California for the enforceability of non-competes. When I say that they're not enforceable in California and in states like Minnesota, Massachusetts, and North Dakota, there is one limited exception that does apply to startups and businesses. And that is if there's a sale of a business, there's a sale of business exception. So if you're selling a business and you sold your business, then you can't go out and start a new business that you just sold, because that's affecting the market share and is obviously competing with the company that you sold the business to. So that is one narrow exception. But other than that, they're just flat out not enforceable, regardless of the time. Even if it's a short period of time, 3 months, 6 months, 9 months, doesn't matter, unenforceable. It doesn't matter what the geography is. If the geography is broad or if it's very narrow, it doesn't matter. It's still unenforceable in California. We're waiting on to see what happens with this proposed rule from the FTC. We suspect, our sort of legal commentators suspect, that even if the law does take effect, it will be struck down legally. There will be legal challenges to it, on the main basis being that the FTC really does not have the authority to basically usurp the state's jurisdiction or usurp a state's ability to govern itself. We've seen that happen in other cases involving these sort of blanket government proposed rules. One such rule being the rule in the United States last year or the year before requiring certain employees of government contractors to be vaccinated. That was struck down and given more power to the states to make that determination because the government was acting beyond its scope or beyond its legal authority to do that. So having said all of that, how U.S. employers protect their interests is really going to turn to how California has protected its interests, and businesses in California have protected their interests all these years that we've not been able to enforce non-competes. And there are three primary tools or ways to do that. The first is by beefing up and making more robust confidentiality provisions. Now, confidentiality provisions, we all have them as it stands, but there's got to be some more teeth to them. In other words, in other states, I'll see confidentiality provisions that say you're not allowed to share this type of information. Otherwise, it will be a violation and we can sue you. That's nice. And sometimes that works. But with more teeth would be to add potentially a liquidated damages clause, which actually says, if you do this, then you pay us X number of hundreds of thousands or whatever the dollar amount is, or pound amount, as the case may be, for this violation. Not only that, but we can seek injunctive relief to go in and stop you from doing these things and then include in a prevailing party's attorney's fees provision. So with that amount of teeth, that will have an employee think twice about whether they want to leave and take certain information with them that would be considered competitive. Another option that some of my California employers use is to incentivize employees to join their organization by adding incentive bonuses as they join. So robust hiring and retention agreements. So if you join us, you get this amount of a bonus. If you stay beyond this period of time, you'll get another retention bonus. However, if you leave, whether you go to a competitor or not, you have to pay this amount back and then some interest and then some additional fees on top of that. If we have to enforce it legally, then we'll get our attorney's fees. So by adding sort of monetary incentives to employment agreements or any other type of agreement, restricted stock agreements, option agreements, that sort of will cause an employee to think twice about whether they leave at all, not just to go to a competitor, but if you really are interested in keeping information or keeping key employees present, you really have to incentivize them to stay. And how do we incentivize employees to do anything? Money, really. So those are two great ways to incentivize employees not to leave, whether they're going to compete or not. And then the last really is non-solicitation agreements. Non-solicitation agreements have been challenged quite a lot in California. However, they're still standing. They're still enforceable. And in terms of the terms and how to make them broader to prevent employees from leaving and competing, non-solicitation agreements can be drafted to include things like you're not to do business with, directly or indirectly, with X type of company or list of customers. Now those are harder to enforce, but they do make sense if you're trying to keep somebody from leaving and actually competing. It's not a non-compete, but it has the practical effect. So a cautionary tale about that, however, is we have a test in California where our courts will look at what the actual effect of the language of your agreement is. So yes, it's true that non-competes are not enforceable here, and we have these other creative ways of protecting our legitimate business interests. But if the court determines that what you're doing is basically an end run around the non-compete, the effect is that you're forcing employees to not compete, the court will still strike down those creative provisions. So it's important that when you're drafting or when you're thinking about drafting these types of alternative or creative provisions in your employment agreements, that the ultimate effect should not be that the employee can't go to work anywhere, that will be determined by the court as sort of a de facto non-compete, and it won't be enforced. So I'd focus more on, unfortunately, money to incentivize employees and make it in such a way that they're still flexible and able to move about to another company, but they'll just have to pay for it. So those are some lessons that we're seeing and some of the trends that we're seeing in the States. We're yet to hear any, we're yet to get feedback about when the proposed rule will become final. These things can take a lot of time. So the sky hasn't quite fallen yet. So for those 46 states that still enforce non-competes in the US, New York being one of them, for any of you who have a business in New York, the sky has not fallen yet. But if it does, there are some ways that we can help protect you in your US business.
All right, thank you very much. Let's see what we can do to help in your UK business. So what options do you have? So one of them is insert head firmly in the sand, wait for the general election and see if this really counts as one of the government's priorities between now and then. It's, I think, unlikely to do so, but we shall see. Better, though, is to have a look at what you've got. Now, the thing about restrictive covenants, including, not limited to, but including non-competition clauses, is that most employers got one from a Butterworth's precedent about 150 years ago and are sticking the same one into contracts over and over again without really any regard to the particular risk which the departing employee would pose. This would be a really good time to go back to basics and say, all right, who here actually would be a material threat if they left? Because straight away you'll find that quite a lot of your people probably wouldn't be. And there may be some where it would be an actively good strategic move to get them into the competition as soon as you possibly can. But you can reduce the size of this problem just by going away and thinking about them as individuals. Is Fred really going to pose a threat to us if he goes? Because if he's not, just don't worry about it. Or if the answer to that is yes, then what can we do? Well, we'd sooner keep him out for more than 3 months. So let's look at extending his notice period, possibly. He may be quite grateful for that if it's reciprocal, because that gives him a big cushion if things go wrong. We could revisit our restrictive covenants because the other covenants, so we could more closely define who the clients were that we didn't want him to get at, or who the staff were, so that those sorts of restrictions become more enforceable, more easily enforceable, and they are not simply some leftover template from years ago that we might struggle with when it came to it. So go back and have a look at those. The trouble with confidentiality wording, of course, is that it only bites once the harm has already been done. Whereas these clauses are designed to prevent that happening in the first place, which is part of the fallacy of what the government says here. But if you've got particular stuff, particular knowledge, and I do mean particular rather than just some blanket description of all technical programs belonging to the company, blah, 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 then put it in the contract and say this specifically is really confidential. And that gives you a stronger hand if and when the time comes. You could think about imposing longer non-competition clauses as part of an equity grant. We'll see from whether the guidance sheds any light on this, but it is possible, as it is at the moment, that would be seen as out with the employment contract. Would be a separate parallel commercial relationship where there isn't any suggestion of imposing this 3-month limit. So attaching it to equity might be a good idea, or options. The retention piece, well, yeah, but remember, you don't generally have non-competition clauses to stop people leaving. You have non-competition clauses to stop them competing. You don't really give a damn if they go to a non-competitor. So yeah, the idea of money has a place, but that's hardly compatible with protecting startups, is it? Who don't really have any money in the first place. So it's not probably something to go for unless retention is more important than leakage. A bit of a different argument. But what about something which says you can go to a competitor if you want? Of course you can. But if you do that, then you will forfeit a whopping sum of money that we were going to give you, or that we will give you if you don't compete. And the reverse of that, if you go to a competitor, you will have to give us back a whopping sum of money that we've already given you. I think the latter, depending on how it's drafted, is probably a penalty clause under English law. I think you'd struggle to make that work. The first one, I think, as Carmen says, it would be seen as a covenant by a different name. It has the same effect. It's designed to have the same effect. And so even though it doesn't say for a moment that they can't join a competitor, it just puts a price on it. I think there's a realistic chance that that would be declared void as well. So I'm in the UK, that is. I'm not sure that would work. And then really the last thing is just get a grip. Now that sounds terribly rude, and I'm really sorry about that. But it comes back to the point earlier. Do we have covenants because we really need them, or do we have them because we've always had them? And therefore, are we properly getting exercised about this? Or is the reality that we just don't need non-competition clauses because people who leave can't really do us any harm? They can, I mean, of course they go, but and so the government piece I showed you earlier in terms of improving recruitment and so on at one level might be right, but one person's improved recruitment is another one's loss of value and IP and investment and so on. But maybe sometimes that's just a cost of business, and you could say we just don't care enough. And so we are going to abandon the non-competition piece and just really stiffen up the non-solicits or the confidentiality and so on. As I said at the beginning, I think this is a daft and pointless little proposal. It may or may not ever happen. It's not the end of the world. If you have a proper, considered look at your senior staff contracts, the only people in respect of whom this is likely to matter, then you're probably going to say, well, actually, 3 months, or even just the length of garden leave, which is going to be 3 months, and it's probably enough. And if so long as he doesn't or she doesn't take our people, take our customers, well, that's just love and war, isn't it? All's fair in love and war. So it's not the end of the world. Don't panic. If you do feel like panicking, then please ring me or ring Carmen, and we will do our best to assist. We've had absolutely no questions at all through the Q&A, which is fine because we're out of time anyway. But if you do have any afterwards and you would like to send them to one or other of us, then you will find us there. And please feel free. We would be very keen to help you on that. In the meantime, I think good afternoon, and that's a wrap. Oh, by the way, before you go, sorry, this has been recorded somewhere, and you will be sent a recording of this, so please don't pass that on to Thameslink Trains, who are going to be quite upset by that, or indeed the government, but never mind. So thank you for your time. You will get a recording. If you've got any questions, ask. And as I say, if you're having trouble with blood pressure, then don't read the government's response to the consultation because it just upsets you. All right. Thank you very much. Speak to you soon. Good afternoon.